7th, 2022 Policy Committee meeting for the School District of Waukesha. I'll call this meeting to order. Thank you all for coming in this early. First, Julie, can you verify that the meeting was properly posted? Thank you. Now would normally be the opportunity for public to speak, but I don't see any speakers. Do we have anybody signed up this morning? No. Okay. All right. So first action item is the approval of the minutes. It's the minute approval from June 27, 2022 Policy Committee meeting. Do I have a motion to approve the minutes?
I so move.
Moved by Mr. Borowski.
Second.
Seconded by Mr. Zenobia. All those in favor say aye.
Aye.
Aye. All those opposed say nay. No nays, no abstentions. Motion passes 3-0. So we have 7 action items this morning. So we'll jump right into those. The first action item is Policy 0100 as to definitions. Do you want to jump right into that, Dr. Cook? Or?
Sure.
Okay.
Before we get into that, though, I just wanted to update the committee on our meeting that we had about 2 weeks ago. The policy that talks about policies, the bylaw that talks about policies, allows the committee chair to assign policies to other committees.
Discussion item. Yeah.
Yep. So if you go to, it's about a quarter of the way into the packet, Mr. Montijo and I met a couple weeks ago. We went through the recommended update, and you can see Julie created a chart there just to show where a number of policies were distributed to. So there were 5 policies passed to teaching and learning, the English language proficiency, human growth and development, library media center, school performance and state accountability report cards, and notification of educational options. So the T&L committee will handle that. Human Resources will handle the student supervision and welfare policies. There are 3 of them. Criminal history, record check, and employee self-reporting requirement. There are 3 of those. Employments of substitutes, there's 2 of those. Benefits, there's 2 of those. And then staff dress and grooming. And then this morning at the Policy Committee, we will be handling definitions, parliamentary authority, independent educational evaluation, open enrollment program, student accidents, illness and concussions, bullying, and then video surveillance and electronic monitoring.
Very good, thank you, and I apologize for skipping over that this morning. There's no other discussion or possible action items this morning, so we can move on to action items?
Yep.
Is that okay? All right. Go ahead. So first action item as before is 0100.
Yep, this is being updated just to add the definition of administrator to try to more clearly identify what an administrator is. So if you go into the policy, and I'm just going to follow along through the packet today, administrator now is, they added the definition, is employed with an administrative contract or someone who directly reports to the superintendent. I think all of our administrators have that, but there's different positions in Waukesha that don't necessarily have the DPI administrative license. So just given our size and some of the responsibilities, we wanted to make sure that anybody who is defined as an administrator is someone who has that administrative contract, which is approved by the board. The other part, if you go to the 3rd page of the policy, under school official, the term school official is inclusive of other parties such as an attorney, contractor, consultant, volunteer, or other party to whom the board has also outsourced a service otherwise performed by the board employees. For example, a therapist or a parent or a student serving on an official committee. So you can see that there's the additional part of that on the 3rd page of the policy.
Very good. Any questions to the administration from the committee? Seeing none, this is an action item, so I'd entertain a motion to approve the modification of policy 0100 as presented.
So moved.
So moved by Mr. Zenobia,
I'll second it.
seconded by Mr. Borowski. Any discussion? And all those in favor say aye.
Aye.
Aye. Passes 3-0. Next action item is policy or suggested revisions to policy 0161, parliamentary authority. So where are we at on this one?
Yep, just to clarify the appointment of a parliamentarian during a board meeting if there's a challenge to the parliamentary procedure. So if the board's in the middle of a discussion, somebody makes a motion of that nature, and somebody calls into question, is that a motion appropriate? The board president can delegate a parliamentarian to help sort through that. So you can see the additions to the policy. When appropriate, the board president shall appoint the parliamentarian who shall decide any challenges to parliamentary procedure. The parliamentarian need not be a board member. I've been in school board meetings before where that has been, the superintendent, for instance, has had that question asked, or there have been meetings where attorneys have been present representing the school district, and the question has been deferred to the attorney, is it appropriate or not? So just for some perspective on that. And then upon request, each board member shall be provided a copy with the rules of order specified in this bylaw. And we follow, kind of a loose Robert's rules. I think it's a informal Robert's rules for our board meetings.
Any questions from the committee for the administration?
I would just be curious, has that ever happened here in Waukesha School District? Have we ever had someone specifically have to answer that? I mean, I know we typically don't have them.
We've had some questions just about like a motion and a modification to the motion, and usually the board, has that little handout in their desks, and that's been enough to handle it. But from time to time, Dr. Siebert has one in his hand right now.
Yep.
From time to time, we've had to, defer to expertise. It hasn't been in a while. We had a board member who was very versed in this a number of years ago, Ms. Pat Madden, and she would often handle these questions for the board, but she was a board member.
Okay.
I remember throughout the COVID, Mr. Baumgart would help out quite a bit. And just as Dr. Cook mentioned, yes, and Dr. Siebert showed, we have been provided these, which are kind of a simplified chart of parliamentary motions, and then we all were given copies of Robert's Rules of Order, which hopefully we all read. But it is, as you mentioned, not loosely applied, but it's not stringently applied. It's not,
Correct.
the rigidity is not meant to replace common sense.
Right.
So, and I don't recall, as to Mr. Zenobia's specific question, that we actually invoked the policy. It was more of relying, on a board member who had an expertise. We all kind of agreed and looked at the notes and the rules and agreed that was the proper way to deal with it. So it's good. I think okay, I'm sorry. More questions for the administration?
No, that was great. Thank you.
Okay. So this is an action item, and entertain a motion to modify policy 0161, parliamentary authority, as presented.
I so move.
Moved by Mr. Borowski,
Second.
seconded by Mr. Zenobia. Any discussion on the motion? Seeing none, all those in favor vote aye.
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 Motion passes 3-0. Next action item is suggested revisions to policy 2460.05, independent educational evaluations.
Yeah, and under the Individuals with Disabilities Education Act, parents of a child with a disability have the right to request an independent educational evaluation. Should we do an evaluation with their child and they disagree with the findings of it? So we have a policy on this, and our policy has been on the books for a number of years. As you can see, it's very comprehensive. At the time that we adopted the policy, we put in the type of assessments. We put in a chart to discuss the cost of those assessments and the criteria that we would expect an evaluator to have. If you look on the third page of the policy, midway down the page, based on this update, and it's a recommended legal update, it says if a district determined that the cost exceeds the cost criteria, then the district must, without unnecessary delay, initiate a due process hearing to demonstrate the evaluation obtained by the parent did not meet the appropriate agency criteria. So from time to time, might be an expert in the field or a proclaimed expert in the field who does an evaluation. That evaluation could be very costly. And we may, as a school system, say that evaluation is not appropriate for this particular area of disability, and then we would have to go to a due process. So this gives us that direction as to what our step would be if we were refusing to pay for that evaluation.
And you mentioned that this revision is required for legal compliance.
Yes, it is.
Meaning,
Well, I mean, I
We
don't
always
want
have
to
a
say you
choice,
have to,
but-
but
right.
if you want to remain in compliance with what we're expected to do by law,
Right.
then we would have to accept this policy change.
Got it. Okay. Any questions from the committee to the administration?
I guess I'm just curious more from the perspective of a parent who maybe exhausts what is offered here and then decides to go and do this, pay money. Is there any, I'm sure there is, but is there any guidance in that process to the parent to say, look, you can go down this path, or this is recommended, or typically we work with this, or I mean, I don't know if it ever happens that a parent would incur a great cost and then this would be, in essence, rejected, which is,
It would be rare that we would reject what's out there. We try to collaborate to the best that we can leading into it. And sometimes when we get into these situations where there's an IEE request, we'll use the special education mediation system to get into a discussion as to what are we looking for? What are we hoping to obtain? We help provide a list of evaluators locally to families. We will extend evaluations, if you will. So for instance, if we did an evaluation in the area of emotional behavioral disability, but there was still some question, does the child have a medical condition for another health impairment that might be creating it? We'll extend the evaluation to cover OHI. From time to time, we get into a situation where we do get an IE request. We operate, within what the guidelines are of this policy, but we don't let a few $100s generally get in the way of us saying, we'll cover the cost of that, because we too believe that maybe we don't have an expertise to try to figure out exactly what this is. So a lot of that is a collaborative process. We have had, and it's been a rare occasion where somebody did, we went through all that process and somebody still did pursue it. And then they did take on the cost for that evaluation. But that has been, in my time here in Waukesha in the last 9 years, that's been a very rare occurrence. We do try to work with the family and help them out with the evaluators and whoever's available.
just how many parents need to have some type of evaluation in a given year? I mean, I know you don't have an exact number, but,
We get maybe a handful of requests for this a year.
oh, okay.
So of the, somewhere between 1,200 and 1,400 evaluations we do a year, we get a handful. A few people will request an IE.
Okay.
And then my team is well-versed in how to go about working with the family to accommodate that request.
Okay, thank you.
Any questions, Mr. Borowski? You mentioned a special education mediation system, I think?
Yep.
Oh, in a nutshell, I'm sure that's a very long explanation, but can you kind of give me a high?
Yeah, so as part of special education in the state, Wisconsin, about 20 years ago, created a mediation system. And so, when we get into situations where the school district and the family disagree on a service, or if the family is making a request that we, through normal policy, process, procedure, can't accommodate, we reach out to the special ed mediation system. There's a director of it. They have a number of mediators that they work with, generally people who are, gone through and been trained as a mediator, people, experience like with municipal contract, negotiations, or are just well-versed in special education. They'll come in and the parties will meet, we'll talk about what the issues are, and then they'll work through that and help guide both parties through the process to come up with some agreements that, we both sides can live with. So you're really working in a collaborative process. I love this process. I mean, as an administrator, if you were to ask, I couldn't count the number of times we've used this to try to come to a good resolution for families. Sometimes it's a very simple thing. Somebody wants their child to be pulled out of school every day early for a therapy. We're bound by compulsory attendance, the IEP services and everything like that. We'll use mediation as a way to help the family with that early release for their child. It's at no cost to the school district, which is great. So you get, you can get into full day, 2-day, 3-day mediations, and we don't have to pay for that. They send that in. That's all built into the state IDEA grant, and it's been very helpful for school systems.
Yeah, at no cost as well. In my line of business, we mediate a lot, and that can be $8,000 a day.
Yep.
Just for the mediator.
Right, and the mediator, they're covered through the system, it's built into the grant, and it has been I think it's a model for all states, and it's been, advertised as such that, a lot of states from around the country have looked to Wisconsin for what they did.
Yeah.
And it is a good tool for families, it's a good tool for school districts.
Glad to hear it. Thank you for the insight on that. Any further questions for the administration on this proposed policy revision? Okay. Seeing none, I'd entertain a motion to modify policy 2460.05, independent educational evaluations, as presented.
So moved.
Moved by Mr. Zenobia. Is there a second?
I'll second.
Seconded by Mr. Borowski. Any discussion on the motion? Seeing none, all those in favor vote aye.
Aye.
Motion passes 3-0. Next action item is proposed revisions to policy 5113, open enrollment program, inter-district.
So, coming up in January, the administration will be presenting our open enrollment space determination to the board for approval. What they did with the policy, and when I initially saw it, I kind of shook my head and thought, why are they making this much change to the open enrollment policy? The more I learned about it, what they actually did is a favor to us and for anybody who looks at the policy is they took open enrollment and they broke it out sequentially for what you do first to like the end stages of what you need for open enrollment. So from a practical standpoint, in this policy, you see a ton of green and a ton of red. They didn't make any substantial changes to the policy. What they did was they reordered it for us so that if you are a new administrator, if you're a new school board member and you were to wonder, what are we doing for open enrollment? You could go to this policy now, and it starts out with space determinations. That's the first thing that guides open enrollment. And it talks about the options there, talks about processing applications. That has all been in policy, so the only change to that really is the order of it. There are a handful of things that I would point out to the committee that stand out, and they're important for people to know. And it's on the first page, just under definitions. These have always been in there, but by providing these definitions in policy, especially in a school district that has open choice like we do, so we can do our in-district choice application, that process has already begun for the school district. This gives us some guidance because people will sometimes interchangeably use open enrollment and school choice and everything else, so I want to be clear on that. There were some options for the policy that talk about, and I just want to get to them, about habitual truancy. So if you go to the 5th page of the policy, if once the board accepts a student under open enrollment, we have always operated that they are our student. We treat them as a resident student. The one caveat that I want to point out is if a child becomes a habitual truant, we are able to make a determination then to send the student back to their resident district. That it can be understood that if you're going to go, parental transportation, there's no busing for school choice, or for open enrollment. So if your parent is bringing you to the district, but they're not getting you here at the grading period, then so at the semester, we can send you back to your home district. Want to point that out. The other statement, Mr. Montillo and I discussed it, and it would be the administration's recommendation that we'll not permit a neighboring district to bus resident students from within our boundaries for attendance at the non-resident neighboring district. If we are going to, we have school open enrollment. It benefits us as a school district in a number of ways, but we don't want to actually be allowing transportation from within our district to another school district. If the family elects that, they can transport, but we don't want to be running buses from taking Waukesha kids out to a neighboring school system. So that would be the administrative recommendation there. And those would be the essential bigger changes to this policy.
Thank you. Any questions from the committee to the administration?
Just one in that last statement you made. Are we currently busing anyone to a?
No, we're
I
not.
don't think so.
No, we're not. But that, with the latest discussions around choice or open enrollment, that became school district could allow it if they wanted to allow it, and the recommendation that I'm making to you is not to allow that particular piece.
Right.
Well, and just to clarify, we wouldn't be busing them, but the other district would be.
The other district would be sending a bus into
Right.
Waukesha to pick them up, and I don't recommend that.
Yeah. And as far as we know, that's not happening.
It's not happening now, no.
Right. And it came up, I think, 2 nights ago at our board work session.
Yeah.
A little bit about that. We had a discussion about that. And Dr. Cook, as you mentioned, you and I spoke about this when we did our prep for this meeting a couple weeks ago. I looked at this, kind of flipped it on its head and say, if we would allow neighboring districts to bus resident students from our boundaries outside, is there any way that would benefit us at all? And there's not a single instance it would ever benefit
No, I
the
don't think so.
district. Okay. So for me, it's common sense. Okay. Any further questions to the administration about the proposed changes to this policy? Seeing none, and entertain a motion to modify policy 5113, open enrollment program interdistrict as presented.
So moved.
Moved by Mr. Zenobia. Is there a second?
I'll second it.
Seconded by Mr. Borowski. Any discussions on the motion? Seeing none, move to a vote. All those, all those in favor of the motion, say aye.
Aye.
Aye. 3-0, motion passes. Next action item is proposed policy, or revisions to policy number 5340, student activities, illness, concussion, and sudden cardiac arrest.
Yeah, so this, if you remember back, I believe it was a year ago, the Kyle Ermer bill, when that was passed, it required that school districts notify parents of sudden cardiac arrest. A number of years before that, we were, as school systems, required to, for athletes, and I'll quantify that, for athletes, we were required to discuss with parents the dangers of concussions and provide them information around concussions, and so we've done that. The sudden cardiac arrest has been added to this policy as a result of the Kyle Ermer bill. It's great information for families, and we've partnered with the foundation to have screenings locally for those that are interested. Our athletic directors have that information. But if you look at the second page of the policy, you see the required information. This is one of those policies that, in order to remain compliant with the law, this would be the language that would be added to it. So it's on the second page. It provides a definition of sudden cardiac arrest, and then it provides our requirements for educating parents, students, and coaches regarding this condition. We do use the guidance that's provided by the WIAA, the governing body for athletics. They put out a fact sheet and information for parents, and so that's what we distribute prior to all sports seasons.
Very good. Any questions to the administration from the committee?
One question, just would it be correct to say that this was basically done for athletes at the time, in the spirit of the bill? I mean, but this will open up to any student over the age of 12?
So we're required to notify athletes, people who are participating in athletics. That's what the requirement is. It would not be difficult if you go past the policy and you look at the sudden cardiac arrest. We have the information. That's what we share with families. It would not be difficult for us to have this posted on our website and available to everybody, just so that they have the information on sudden cardiac arrest. But our obligation is to deal with it in the realm of athletics.
And then they would take, how is the service provided? I know we're not providing it, but they would, it's to inform the parent of the possibility that
Right.
there may be an issue.
Yeah, that it is, that it is a possibility that this could be a factor. Like I said before, the foundation, we've partnered with them to use some of our locations where they can do screenings that are open to anybody who's interested. So they have EKG machines. They have volunteers that come in. Our kids can sign up and participate in the screening. If anything is detected, the parents and the child are notified that they should follow up with their doctor to see if this is actually a condition that they have or if it's, another abnormality that might be, with their heart. So yeah, I mean, it's definitely a good screening tool, for.
Yeah, no, absolutely. And I agree, and I would just, point in raising that is just the awareness for parents that, maybe hadn't considered this, to go and look, and especially in light of things recently that have concerns about heart issues. So, any awareness that can be raised is a great thing, and this bill does that and will continue to do that. I just hope that that's apparent to all the families and students in the district, that they have an opportunity to go and do this.
Yep.
So,
Mr. Borowski?
Yeah, right after the policy, there's another page on sudden cardiac arrest. I don't know if you mentioned it or.
Yeah, that's the sheet. This is the information sheet that is shared with families.
Okay,
And this was created by the WIA.
gotcha. All right, I must have missed that.
Any further questions? Okay. I know it's early, so apologize my misunderstanding this, but this requires notice to athletes and those involved in those activities, but we could orally amend this and to direct the district to put this on its website
Yep.
as well.
Good.
Okay.
Yep.
All right. Any further questions?
No.
Okay. If I may, I will move to approve the revision to Policy 5340, student activities, illness, concussion, and sudden cardiac arrest as presented, but with an oral amendment directing the district to post the warnings that they would normally provide under this policy to the athletes pursuant to this policy, but also post it on its website for availability to all students.
Yeah, there's two areas that we could put it. We could put it under the information for families. There's a kind of a drop down there, and Julie can work on that.
Okay.
The other area that we can put it on is just we have annual notices, legal notices that we put out, and we could put sudden cardiac arrest under that section too. So families would have, people who view our website could see this in two locations.
That'd be great. Okay. Motion by Mr. Montiel. Is there a second? Second by Mr. Zenobia. Any discussion on the motion? All those in favor say aye.
Aye.
Aye. Motion passes 3-0. Thank you for the direction and suggestion on that, Dr. Cook. Next action item is proposed revision to policy number 5517.01, bullying.
Yep. So the additions to this are under complaint procedures. Complaints against the board member shall be filed with the board president unless the complaint is against the president, in which case the complaint shall be filed with the board vice president, who is authorized then to contact district legal counsel for assistance in handling the complaint. So should there be instances where a board member was bullying, the other addition here is it's the addition of the non-discrimination and equal access to educational opportunity language. So they want they're recommending that we add in the non-discrimination language into the bullying policy. So should you be investigating bullying and you find out that it turns into some sort of discrimination or harassment, that you could be directed there. And then again, it adds the language in there, if the matter or complaint involves a superintendent or a board member, it's appropriate to engage outside legal counsel to conduct the investigation. The person who is accused obviously cannot investigate their own conduct.
Right. Any questions for the administration from the committee?
just really a clarifying question, I suppose. Is this part, is this finding its way into any additional policies, or is bullying the only one? I mean, this would be harassment, I would assume.
The
well.
harassment and discrimination language already has in the language about a board member or the superintendent.
Okay.
So that is already spelled out in there. It was not in the bullying policy, but kind of in light of, say, the last 2 years' worth of experience, it's been recommended that it be built into the bullying policy as well.
Okay.
Any further questions? Seeing none, entertain a motion to modify policy number 5517.01, bullying, as presented.
So moved.
Moved by Mr. Zenobia. Is there a second?
I'll second.
Seconded by Mr. Borowski. All those in favor say aye.
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 Motion passes 3-0. The seventh and final action item is the proposed revisions to policy number 7440.01, video surveillance and electronic monitoring. Where are we at on this one, Dr.?
Yeah, so two substantial changes are not, one of them isn't very substantial. They changed building principal to administrator. We, at the district office, have the ability to access the video surveillance footage from a school. So since we're not building principals here, it just wants to be more global in its reference. The substantial change, or the recommended change, the video footage should not be removed from school officials' custody except as required by law or upon request from law enforcement. The video footage falls into the realm of a student record, so we would need to maintain and protect that like we would a report card, a transcript, an office discipline referral. So we don't distribute video footage unless it's required by law to help with an investigation.
Right.
We can allow somebody to come in and view the footage. If there's a family who wants to see something, we can offer them to come in and view it, but we don't release that footage to them, again, unless there's some sort of court issue that would require us to do so.
Very good. Any questions for the administration from the committee?
Maybe a clarifying question on the video footage. So currently, all of our video surveillance, what have you, is done internally, is that right? So anything that we have, only we see?
Yep. So we record it, we maintain it, and that's maintained on our servers. So should we need to look at something that happened at a school, we can do a look back of 30 days and see what is there. After 30 days, it rewrites over the top of it, so we lose that footage within that 30-day window. Or after that 30-day window, I'm sorry.
So if we have a third party that provides some of the technology, if you will, do they have access to the footage currently? If they
We
want
don't currently have a third party. I mean, we have vendors that help us with cameras.
Sure.
They do the installation, they'll make recommendations, they'll help us do the wiring of it. But all of that is currently maintained in-house for our access.
If that would change in the future and a third party would have access, how would we police that footage is concurrent with a policy like this?
That would be written into the contract. So if it ever went to a cloud-based storage, whoever managed that storage would be, they would be obligated by that contract to protect that footage as if it's a student record. And there would be access levels given to that, given to the district and given to that company for the access to that footage.
Okay. Okay, thank you.
You're welcome.
Any further questions for the administration from the committee? Seeing none. I had questions, but Mr. Zenobia's questions were mine, so. Okay, so I'd entertain a motion to modify board policy number 7440.01, video surveillance and electronic monitoring as presented.
I so move.
Moved by Mr. Borowski,
Second.
seconded by Mr. Zenobia. Any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Aye. Motion passes 3-0. That concludes the action items on our agenda, correct, Dr. Cook?
Yes, it does.
All right, so other business, any recommendations for future committee meetings from anyone?
The only recommendation, it's more just an update. When we get the next round from Neola to look at, we'll go through the same procedure. We'll start to sort them administratively and look at them. I'll meet with Mr. Montijo. Per Mr. Montijo's, purview, he can distribute those to TNL, FNF, HR, whatever, student services, for consideration. And then we would have another policy committee meeting at that time. Generally, those releases come sometime, I don't know, Julie, when is that next one going to come? Either January or February, maybe, just depending on the window. Then the next one would come sometime in the summer, and then, so it's about twice a year we get an update from Neola.
So it's Neola who's really kind of driving the revision schedule, and it's not us saying, hey, this policy's old, we need.
It kind of comes both ways. The nice thing about Neola is that they stay on top of the policies for us. So when we started with Neola, just a little bit of history, when we started with Neola, we had policies on the book that hadn't been updated since prior to my birth. So there were policies last revised in 1974. A lot has changed since 1974. So Neola keeps that fresh and current for us. But there are some policies that the board wants to consider or that the administration recommends that we make changes to. And so the board or administration always has the ability, a citizen always has the ability to make a recommendation to discuss a policy. So they drive us in the sense that they help us keep current on things.
Sure.
But they don't prevent us from addressing a policy. For instance, staff dress and grooming. That came up through the HR committee, and that can happen with any of our policies, should a board member, administrator, citizen want us to talk about something.
Do you know what typical timeline is? Let's say a board member suggests or anybody suggests that a policy get reviewed. Do you know how long it takes them to?
Usually Neola is not involved then in that. That would be our work. So that really then falls on the committee chair or the board president, and then the administrator as to like when that fits in the meeting cycle. Sometimes policies are recommended, but you already have 10 items on your committee agenda, so you hold that off for a month.
Any more questions? No, I would just mention, I've seen over my years that we've had policies through COVID and whatever that were urgent, and they were brought up and they were addressed within, the very next board meeting.
Yep.
And some just functionally have to take longer.
Yep.
But yeah, the process I think is great. I still get questions about why the policy committee does not regularly meet, and they're valid questions and they're important questions. It was Dr. Piazek, as part of her leadership, looked at creating efficiencies in the committee structure, and it was, I think, a genius thing to do. It's simply, it doesn't make sense to hold meetings if there isn't work to do, and it doesn't make sense to make work so we can justify holding a meeting.
Yep. And it does put the policies in the appropriate committee to talk about those. So there is policy discussion happening essentially monthly,
Yeah.
maybe every other month. Just it depends on which committee is addressing those policies.
Right, so basically acting as somewhat of a gatekeeper to push those policies to some policies are clearly HR. There's nothing that could possibly have anything to do besides HR, and that should go to HR, instead of dealing with it policy and then bumping it up. So I think it was a smart move, and I appreciate the efficiency and how it's been handled by the administration and the board, so.
And just to clarify on that as well, looking at the chart that Julie put together, if we do ever want to pull or recommend a policy come back to our committee or some other committee, that's our decision.
Yep, we certainly could have something come here to be discussed. That would just be up to Mr. Montijo's schedule as the chair, as to do we want to entertain it or not. I mean, the committee chair is ultimately the one who's going to set the agenda, and so the committee chair could also say this is more appropriately discussed somewhere else.
Mm-hmm. So what I'll do in the future, next time this happens, is when I get or presented the suggestions by the administration, I'll copy both you on those suggestions. And if you see something that you may want to have some questions about, we can circle back. Otherwise, I'll proceed as we normally do, and
Sure.
just to kind of head that off in case
Just for perspective, the committee will address it first, but the whole board then gets a crack at it
Right.
after that committee meeting. So these policies that we discussed today will
Right.
be on the board agenda next week. Anything that goes through HR, TNL, whatever it might be, they will eventually be in front of the whole board for a whole board discussion.
Very good. Any suggestions for future meetings? I know I kind of asked that. No future meetings. Then we are adjourned. Concludes our agenda. Next policy committee, as we mentioned, has not yet been scheduled, but it should be scheduled in the next few months. So thank you all for coming this early this morning. Have a good morning.
Thank you, everybody.
Thank you.